Is a handwritten will valid? It's a great question. Hey guys, it's Brad again from GeorgiaProbateResource.com. We're a real estate solutions company in Metro Atlanta, but we buy houses all over the state of Georgia, and we specialize in the world of probate and inheritance properties. So if you either want to sell the house for a fast cash offer, don't want to mess with it, just want this easy, quick, and done, we can help you with that. Or if you want to go the traditional route and list it on the market with an agent, I am an agent myself. I specialize in probate. I'd love to help you with that as well. So is a handwritten will valid? And that's a great question. And the answer is, well, sort of. There's something called a holographic will. And in Georgia, a holographic will is considered a handwritten will that is hand-signed with no witnesses, and in which case a holographic will is not considered valid in Georgia. But there's nothing in Georgia that says you can't handwrite a will, but if you have witnesses, many times that would be okay. Ultimately, you're going to want to have a probate attorney review this for you, and they'll be able to tell you whether or not they would think that will is valid, because ultimately the judge is going to look at the documents, the court's going to look at it, and they're going to determine whether they think it's valid or not. The big thing is you need to have at least 2 witnesses on that document, and it's always a good idea to have those witnesses sign, and it's also a good idea to have those witnesses provide some sort of contact information. So in the future, if you ever needed to contact them, they could be contacted. We've actually had an instance with a probate deal that we did a few years ago where we had to actually reach out to one of the witnesses. And fortunately, they had provided a phone number there, and we were able to talk to them, and they did, in fact, confirm that they did witness the will. In my case, in my personal will, I'll just share this with you. My personal will, I had an attorney prepare it for me. At the bottom, I signed it. And then I actually had 2 witnesses and a notary. So we had a notary, I signed it in the presence of the notary. Plus we had 2 independent witnesses that were not the notary that signed it as well. In some cases, some attorneys might also prepare what's called a self-proving affidavit with that as well, that basically just further, you did this will and blah, blah, blah. You didn't do it under duress. Because that's another caveat there that I'm not really going to get into this video. But if someone prepares a will under duress, that could be considered invalid. But again, I'm not going to get into that in this video. So answers your question pertaining to handwritten wills in the state of Georgia. If you need a referral to a great probate attorney, we've got a fantastic network of probate attorneys that we can refer you to, that we work with all the time. And again, if you want to sell the house, you've inherited this house and you don't want it, you just want an easy, no BS, fast cash offer, we'd love to chat with you about that. We can make you an offer on the property and buy it from you. We can close in as little as 2 weeks. We'll even buy it with all the stuff in it. In fact, most of the probate and inheritance deals we do come with some amount of stuff in them. Or if you want to go the traditional route and list it the traditional way with an agent, I am a licensed agent with OneSource in Woodstock, and I'd love to talk to you about listing the property as well. So thanks again for checking out this video. I hope it answered your question. I hope you have a great day. Thanks. Bye-bye.